about and demystify about what does Uniform Civil Code actually contain. Because now we have the Prime Minister and the Law Commission asking from the people recommending how Uniform Civil Code to be. So we to discuss whether we need the Uniform Civil. I'm having trouble. I think Vishnu ji, are you? We're just having little problem with the internet. Vishnu ji, not able to see you.
मैम आप देख पा रही हैं मुझे?
Can you please? Okay.
मैम आवाज आ रही है?
हाँ, आवाज तो आपकी पिक्चर नहीं आ रही, जरा क्या
मैम मैं तो अपने आप को देख पा रहा हूँ।
हाँ आएगी टेक सम टाइम। ओके, नमस्ते विष्णु जी। नाउ
नमस्ते।
हाँ मैं पा रही हूँ।
आपका नेटवर्क काफी वीक है, आपकी वॉइस बहुत इको हो रही है।
या आई कैन सी यू। Okay, I'll just check my network. 1 second. Yes, Vishnu ji. Yes. I'll just remove this. Okay. Thank you, Vishnu ji, for gracing our program. Please do demystify what does Uniform Civil Code consist of, and do we really need? Does Bharat really need Uniform Civil Code?
See, a very good evening to all of you and namaskar to everyone. See, when we are discussing about this very important topic like Uniform Civil Code, I must tell you that the concept of Uniform Civil Code is imbibed in the Constitution by way of Article 44 of the Constitution of India. And the wordings which has been used is the state shall bring a law to implement the Uniform Civil Code. Now, the question is that when this was initially discussed while drafting of the Indian Constitution, it was an idea that there must be a uniform law so far as certain aspects are concerned. But what are those aspects that were left undiscussed? And it was for the parliamentarians and the parliamentarians of the current time to discuss and decide those issues as to on what issues we are seeking uniformity. I have gone very deep into the matter, and I've read this matter from all the aspects. And after having deliberate discussion and with various members of the various communities, it what has come and emerged to light is this, that there are certain areas where we are seeking uniformity, where the members of other sections of the society are feeling discriminated, like, and I will enlarge this topic further, like the age of marriage, number of marriage, as well as there are certain aspects which are called as a kuriti in many societies, which must be stopped. Like iddat period is there in one section of the society, which must be stopped. Then there is a halala, which must be stopped. Then there is very serious issue which is called female genital mutilation.
Yes.
female genital mutilation, which must be stopped, and then there is the issue of polygamy, which must be stopped. So there are certain issues which have to be stopped with iron hand, and the law has to be implemented across the section, all the sections of the society. Because let me tell you what is happening and where the anomaly lies. The anomaly is this: that today, if I am saying that if I am a Hindu and I want to marry despite my spouse living more than, I want to have one more marriage despite my spouse living, there is an offense under the IPC by virtue of section 494. Because section 494 IPC has given exemption so far as personal laws are concerned, and Jawaharlal Nehru in 1955 enacted the Hindu Marriage Act, and there adultery and bigamy was made as an offense. So therefore a Hindu cannot have a spouse living and have more than one marriage, which will be punishable under IPC by virtue of section 494, and there is 7 years of imprisonment. But so far as members of Muslim community are concerned, they can have four marriages, and there will be no punishment so far as Muslims are concerned under section 494. So I am talking about uniform civil code with aspect of where there is a criminal provision for various sections of the society, but the same aspect is not criminal
Mm.
for one segment of the society. Like
Yes.
bigamy is a criminal provision so far as Hindus are concerned, Christians are concerned, Parsis are concerned, Sikhs are concerned, Buddhists are concerned, Jains are concerned. But bigamy is not an offense so far as Muslims are concerned.
Absolutely.
So
Vishnu
there
ji,
has to be a uniformity. So
doesn't this sort of give
yes,
impetus for conversions? Because men, Hindu men who want
definitely.
to marry more, then they convert to Islam. We have seen many such cases.
You have asked a very, very pertinent question, and that's what my second limb of submission was, that bigamy, which is section 494, which gives exemption so far as personal laws are concerned, is a way forward to convert. Because many men who have more than one marriage and have affairs, they take the escape route, the route of um, choosing Islam over Hinduism, and then it leads to conversion. So, therefore, Section 494 IPC has to be implemented across the sections of all the society, all the communities, irrespective of a religion. And there's a very basic principle under criminal law, that criminal law will be uniform for all the sections of the society. If suppose someone is committing an offense of theft, so he will be awarded the same punishment which a Hindu is awarded, or a Muslim is awarded, or a Christian is awarded, or any section of the society is awarded. So you cannot say or argue that for a Muslim, if he commits theft, he will be governed by Sharia law, hands will be cut, and if a Hindu commits theft, he will be governed by IPC. Both have to be dealt with the same penal code, and therefore section 494 IPC has to be amended. Because when and how will it happen? It will happen in the way that first the personal law
Hmm.
will be amended, the Sharia Act 1937 will be amended, and after that it will have a direct implication so far as wordings of section 494 are concerned. Now my second point, which is a very, very serious issue, is the aspect of child marriages.
Hmm.
We all know that in India there is Child Marriage Prohibition Act 2006, but despite that, it does not apply to certain sections of the society, because they claim that there is an exemption so far as their personal laws are concerned. Now, let me give you an example of Kerala High Court. Khalidur Rahman versus State of Kerala is a judgment where a minor girl was abducted, she was raped, and when the matter came up before the Kerala High Court, an argument was raised by the offender that I have married this minor girl and it is permissible under my religion, therefore it's not an offense under the POSCO Act. Now, we all know that POSCO Act is one of the most serious and heinous offenses which the Parliament has enacted by way of POSCO Act 2013. But the certain sections of Muslim community and the majority members of Muslim community are saying that the POSCO Act is not applicable to us. But the Kerala High Court in Khaldur Rahman versus State of Kerala ruled that no, a member of Muslim community will also be governed by the provisions of POSCO Act. I must tell you that four high courts have taken a divergent view. Four high courts said that no, POSCO Act does not apply to the members of Muslim community, and therefore uniform civil code is necessary. It is the need of the hour, because if POSCO, if something is done under the purview of POSCO Act, and and it's an offense for entire section of the society, for all the citizens, then you cannot say that it will be exempted for a particular religion. My
Hmm.
third point is, so I wanted to highlight this issue, that age of marriage is very, very important. Number of marriage I have highlighted in your show, that number of marriage has to be controlled and has to be checked. If everyone has to follow the same rule of one wife, then the second important aspect is of age of marriage, which is very important. We all know that in India there is a law which says that the age of a girl marrying will be 18 years, and for a man for male it will be 21 years. So it has to be followed across the board, across all the religions, and there cannot be any exemption so far as personal laws or religion are concerned. My third submission is, and third very, very important area is, that there are certain things which are called as kuriti in many religions. And I must highlight and flag this issue today before you, that there is a practice called female genital mutilation,
Yes.
which is a very, very heinous and serious offense, which goes to the dignity of women, which goes to the gender justice issue, and which is the most heinous offense under Section 3 of the POSCO Act.
Yes.
The matter is pending adjudication in the Supreme Court before a seven judges bench of the Supreme Court. But till today, we are not able to decide that whether this female genital mutilation is an offense or not, because the argument is that it is permissible under a particular religion, it is permissible under the custom and usage of a particular religion. So female genital mutilation is not an offense. So the point is that if POSCO Act is saying that this is an offense under Section 3, and you are claiming exemption so far as your religion is concerned, I ask a question to myself: does it not call for a uniform civil code so far as these old age practices are concerned, which are most unhuman, which are most inhuman, which has been criticized by UNICEF, which has been criticized by United Nations, which has been criticized by WHO? So age of marriage, female genital mutilation, these are the practices which has been criticized by United Nations, WHO, UNICEF. So this is an issue which has to be uh, highlighted, and for this uniform law is required.
Hmm.
I must also tell you that there are practices like iddat period, which has to be abolished. It goes to the root of the matter. It is a female justice issue, gender justice issue. Then there is talake hasan, talake, uh, other forms, halala. So these
Hmm.
are the issues which have to be stopped. These are the practices which must be stopped. And I must tell you that so far as Hindus are concerned, there was a sati practice which was happening in Hindu community, and our scholars, our acharyas, they felt that, and they felt that this sati practice must be abolished. Sati Prohibition Act was brought by the parliament, as well as in the British era. There was a practice amongst Hindus that widows will not remarry. Widows Remarriage Abolition Act came, and after that, widows were allowed to remarry. So we have whatever was there in our society, we have developed as a society, and we have come forward. There was a practice, I must tell you, in Rajasthan, that after Tervi, you have to throw a huge Tervi bhoj, and many members, poor segments of the society, were feeling the pain of this practice. The Rajasthan government, not the BJP government, the Congress government came up with a bill and act saying that this Tervi bhoj must be abolished. And now the people of Rajasthan are feeling relieved by that practice. So there is then, therefore, there was this age of marriage, which I'm saying the Child Marriage Protection Act came, which was applied to members of Hindu community. The Hindu law was codified by Jawaharlal Nehru in 1955. The Hindu Marriage Act came in 1955. And I must tell you that so far as this aspect is concerned, there is no concept of, under the Hindu law, of divorce. For
Hmm.
us, Hindu marriage is a sacrament, it's a
Yes.
sanskar, and it's a relationship for seven, सात जन्मों के लिए वो रिलेशनशिप होता है. पर जवाहरलाल नेहरू साहब ने हिंदू मैरिज एक्ट 1955 लाके डाइवोर्स का कंसेप्ट इंट्रोड्यूस किया, जो
Yes.
हमारे एसेंशियल रिलीजियस प्रैक्टिसेस के खिलाफ है. बट देन आल्सो वी आर एक्सेप्टिंग इट. So it is not that we have not gone through codification. We have gone through codification, and now the time has come that we must codify the other religions who are violating the three very important factors. And I must tell you that Article 25 of the Constitution of India uses the word that every religion is subject to public order, health, and morality. So you cannot say that you will violate something which is against public order, you will do something which is against health, you cannot do something which is against morality. In Himachal Pradesh, the Himachal Pradesh High Court struck down the practice of Bali, and the
Hmm.
matter is pending adjudication before the Supreme Court. So the point and issue is that this is not interference with any particular religion. This is an interference so far as the law of the land is concerned. If the law of the land is POSCO, if the law of the land is Section 494 IPC, if the law of the land believes that under Section 3 of the POSCO, female genital mutilation is an offense, if the law of the land feels that talake, this iddat period is a most inhuman form and it's in
Hmm.
violation of female's dignity and Article 21, then it must be scrutinized. If the law of the land feels that halala is a completely inhuman thing and it
Hmm.
is against female dignity and female justice and gender justice and against the virtues of Article 15, then it must be debated and it must be answered by the parliament. And now the time has come that all these practices will be debated before the law commission, all these practices will be debated in the parliament, and all these practices must be brought to an end.
Vishnu ji, I have a question. Like, for example, FGM is banned even by the UN. So,
Mhm.
FGM, and as far as POSCO law violations are concerned, and even polygamy, I mean, banning polygamy completely, all this can come under IPC reforms. We don't need a
Yes,
civil code for that. Uniform, because there are certain aspects of the uniform civil code which can affect even the Hindus. For example, we have the joint family property system, which is governed by the Mitakshara laws. That was diluted in 2005 and even in 1955 when they started, 1956 when they started the HSA. Then we had, because the effect of it, one thing I would like to ask you, in Kerala, the joint family system itself was abolished in 1975. I believe that the existential crisis which Hindus face today in Kerala owes mainly to this act of abolishing the joint family system. Can you please speak about this?
yes. I will first answer your question. That your point was that for bringing uniform civil code, there has to be an amendment in the IPC, and if this IPC is amended, then there is no need to bring uniform civil code. I must disagree with you with certain riders. And the
Hmm.
point is this, that if we understanding wording of Section 494 IPC, there is an exemption given to the religious practices. So that's what I'm saying. And my point is that you have to first codify, you have to first bring an amendment under the
Hmm.
Sharia Act, or you have to codify that personal law which gives that exemption to have more than one marriage
Hmm.
despite your spouse living. And when it will be an offense or it will be not allowed under your personal law, then the provisions of IPC will trigger in. The other way to do it is this, what you are saying is that you cut off that exemption which is there in IPC, giving an exemption on the basis of your personal law, and then it will
Hmm.
be an offense for all the sections of the society, and you have to bring an amendment saying that this provision of the IPC will apply to all the religions irrespective of their personal law. The
That's true.
third important aspect is that so far as POSCO Act is concerned, you have to bring an amendment in your personal law so that the POSCO Act can be applied. You have to overrule all the four judgments of the different high courts who have taken a view that the POSCO Act will not apply to non to Muslims. It will not apply. All those views you have to override, and you have to say that no, POSCO Act will apply despite any practice in any religion. So this is a very important aspect. And the fourth question which you have asked is about the Hindu undivided family being abolished in Kerala. Let me tell you that we are governed by Mitakshara and Deyabhaga law. Now, the concept of Hindu undivided family, many people debate and say about and talk about this topic, that whenever uniform civil code will come, the Hindu undivided family concept and the tax exemptions will be taken away. But let me tell you that under Muslim law, there is a provision of hiba, that
Hmm.
you can do gift, you can give gift by way of an oral gift, and there is no registration, no stamp duty, no tax so far as hiba is concerned. So here we have to be very very careful when we are discussing about uniform civil code. And therefore I have highlighted in the starting of this entire debate, that what are the areas where we are looking for uniformity. And the question and the principle on which I am sticking to today is that we are looking for uniformity on areas which are penalized.
Mm.
for various communities, but they are not penal so far as certain sections of the society
Yes.
are concerned. Let me also tell you that when we are discussing about uniform civil code, I must tell you that under section 10A of the Indian Divorce Act 1869, there is a mandatory period of waiting of 2 years for a Christian couple who wants
Mm.
to take divorce. There is a mandatory period of 2 years waiting period, which
Mm.
has been challenged in the Supreme Court, for which we need uniformity. So far as grounds of divorce are concerned, there are certain suggestions by various members of the society that we need uniformity so far as that is concerned. So far as Parsi women are concerned, if they marry outside their community, they will not be allowed the right of inheritance. So this also has to be looked into. So these are the areas. These are Then there is an area of compulsory registration of marriage. Then there is also a suggestion that leprosy, which is a disease under the Hindu Marriage Act and a ground of divorce, must be taken out because now it can be cured. Then there is also a suggestion that Section 9, the restitution of conjugal rights, must be taken away because it's a age old British law. So
Mm.
when the matter is now open before the law commission, I'm saying that we all must give our suggestions,
Mm-hmm.
and we all must agree on certain very very basic aspects, that if law of the land, if the penal law of the land has declared certain things as offense for all the members of the society, then it must be for everyone, and there should be no exemption so far as the religion is concerned.
Absolutely, absolutely right, Vishnuji. And then there is this aspect, like for example, in the HSA, we have a provision which says that a convert's child cannot inherit Hindu property. This also safeguards people from converting. I mean, and taking away the property also. So, would this be lost when we have a uniform civil code?
I don't think so. I don't think so. As I have highlighted further, I highlighted earlier also, that we are talking about uniformity in those areas where, subject to public order, health, and morality, a religion you can practice. So, where
Mhm.
anything in a particular religion is offensive against the public order, health, or morality, there
Mm.
we are talking about uniformity. Uniformity is not going into the personal laws of a person. Like, for
Mhm.
example, I must tell you that under the Hindu Marriage Act 1955, there are prohibited degrees of relationship.
Yes.
There is a ban on Sapinda relationship. So we
Mm-hmm.
are not saying, or I don't think that as of now this debate has come forward, or this suggestion has come forward, that this concept under Hindu law must be applied in Muslim laws. This concept is not applied under the Muslim law. So we have restricted ourselves so far as uniform civil code is concerned to those areas which is subject to public order, health, and morality. And let me tell you that when Article 44 was implemented by the Constitution, by the framers of our Constitution, the
Mm-hmm.
concept and idea was that Article 44 has to be
Mm.
implemented. What are the subjects which were to be decided by the parliamentarians? And let me also tell you that if a law is brought to implement the provisions of the directive principles of state policy, and especially
Mm.
Article 44, that law cannot be challenged on the touchstone of Article 14 and 19, because now Article 31C has been introduced in our constitution. And therefore, if any law is brought by the parliament or by the state legislature, I must tell you also that Uttarakhand government has appointed the law commission, a committee so far as to conduct a survey and make a
Mm-hmm.
draft suggestion so far as uniform civil court is concerned. And the committee headed by retired judge of the Supreme Court, Honorable Mr. Justice Ranjana Desai, has
Mm.
done a tremendous work, and they have submitted their suggestions before the Uttarakhand government. And now the Uttarakhand government will think further and bring a bill, and then the bill will take the shape of an act. So the
Mm.
point is that these acts can be passed by the parliament. This act can
Mm.
be passed by the respective state governments. The Law Commission of India has also invited suggestions. I believe, and I know that around 10 lakh suggestions have been given to the Law Commission of India. So now
Mm.
this all these issues are debated upon, and what
Mm.
has come forward as of now are these important areas where we are seeking uniformity.
Mhm. So we are seeking uniformity in the narrow section of where affects the public health and morality of people. That's the only area we'll have uniformity. It does not mean that we'll uniform the entire religious aspects,
Yes,
because that varies from religion to religion.
yes,
And then for example, we have certain things like we had this Sabarimala temple issue, where the court said it rammed in literally that the women should be allowed when there is a custom of women not going there, the menstruating women from 10 to 50, because it is based on certain important thing, because the god there, I mean the main deity there is a brahmachari. So I
Yes.
hope such things would not be sort of rammed in a uniform civil code. We'll be left to our own religious practices and traditions. It won't
I don't
in,
think so. I personally feel and believe that because see, no one has seen the draft of Uniform Civil Code. It's still at the very initial stage where we all are discussing as to what are the areas where we are seeking uniformity. And my constant view from very beginning on this topic is that the areas where I am seeking uniformity is so far as the practice of bigamy is concerned, so far as the practice of age of marriage is concerned, so far
absolutely.
as female genital mutilation is concerned, so far as iddat period is concerned, so far as halala is concerned. These are the areas where we are seeking uniformity. And so far as Hindus are concerned, Hindus, within the definition of Hindus, the Jains are also included, the Sikhs are also included, the Buddhists are also included. And the aspect is that we have already been codified in 1955 by Jawaharlal Nehru. So now
Hmm.
the time is that this codification must apply to the other sections of the society. And really, it's an issue which I have highlighted before you today. It's an issue of female justice, it's an issue of gender justice, it's an
Hmm.
issue of female dignity. And such kind of practices cannot be permitted in any section of the
Absolutely.
society. So far as Shabrimala is concerned, let me also tell you that there is an issue that the Muslim women are not allowed to go in a mosque, and that
Yes.
issue is pending adjudication before the Supreme Court. But I don't think that these are the areas which are presently under discussion or deliberation so far as this uniform civil court is concerned, because there is a particular issue where we are drawing a line that
Hmm.
we will not interfere in a
Hmm.
particular, because definitely it's there is no doubt about it that when you are bringing uniform civil code, you are interfering in certain practices of a religion. It's a different matter, and it's a issue of argument by both the sides that whether this is an essential religious practice or not. And if it is not an essential religious practice, then definitely the constitution will prevail. I must also highlight before your in your show that the Supreme Court in 1997 4 SCC page 606 has held the judgment of Justice Ramaswamy that
Hmm.
Constitution of India will prevail over any section of the society, and the religion or denomination of a religion, their practices would not prevail over the Constitution. The Constitution of India will prevail. And therefore, I am highlighting again and again on your show that under Article 25, the words which are used is subject to public order, health, and morality. So no religion can say that they will do something which is against the basic theme and ethos of the penal law of this country, which is against the basic theme and ethos of the IPC or the POSCO or various other laws passed by the parliament. So those are the areas where we are concentrating.
If Vishnuji, I have noticed, for example, the FGM part, the case is being in the Supreme Court now for many years. I mean, this is an open and shut case. FGM needs to be banned. It can be banned by a simple IPC law also. I mean, even that can take care of it. Either the
That law
government,
is already there.
okay,
You are
that,
right.
yeah,
That law is there under Section 3 of the POSCO. But
also.
a certain section of the society is seeking exemption so far as their religious practices are concerned. So this is an issue that whether if you are doing something which is against the POSCO Act,
Mm-hmm.
and you are saying it is against it is protected by your religion, so there you will not get the shield of protection of your religion. That's a very narrow area where we am debate where I'm talking to you today. And that's why I said that the Child Marriage Protection Act, Child
Mm-hmm.
Marriage Prohibition Act 2006 will apply to all the sections of the society. You cannot say that I am entitled to marry a girl of 9 years
Mm-hmm.
and it is permitted under my religion. You have to follow the law of the land. If a Hindu cannot marry a girl less than 18 years of age, or any other religion, for Buddhist, Jain, Sikh, Christians, then it has to apply to every section of the society. And I must also highlight today on your show that when we discuss and debate about uniform civil code, we talk about scheduled tribes also.
Yes.
The scheduled tribes under Article 371A and 6th
Mm-hmm.
schedule have a special protection so far as their custom and usages are concerned. And when the issue of uniform civil code have come forward, many scheduled tribe states like Nagaland, Mizoram, Meghalaya have passed their assemblies, have passed an uh, uh, resolution saying that they will not agree with the uniform civil code. But let
mm,
me tell you that the constitution has already taken care of the practices of scheduled castes and scheduled tribes, and especially scheduled tribes. I'm sorry to scheduled tribes. And Article 371 has said, 371A has said that if a parliament brings a law so far as interferes with the custom or usage of any members of the scheduled tribe, then it
mhm,
will be presented before the legislative assembly of that scheduled tribe area, and then
mhm,
it will be debated further. And if that assembly passes the law passed by the parliament, then only it will be implemented. So
mm,
far as protection to scheduled tribes are concerned, it has already been taken care of by the parliament. But let
mm,
me also tell you, and I am very, my position is very clear, that certain areas which I have highlighted today on your show, like polygamy,
mm,
bigamy,
mm,
female genital mutilation,
mm.
various other practices which are a kuriti in a
Yes.
particular religion, you cannot take shelter whether you are a scheduled tribe or whether you are of any religious denomination. There has to be a grand norm. There has to be a very clear law so far as all sections of the society is concerned on a very important issue: gender justice, female dignity, female justice are the issues where we are seeking uniformity, and where, despite scheduled tribe, irrespective of whether you are a scheduled tribe, a Muslim, a Jain, a Christian, a Buddhist, a Hindu, this kind of uniformity must be brought, because this is against public order, health, and morality. And I am not saying, you read the Declaration of Universal Declaration of Human
Absolutely.
Rights, you read the declaration of UNICEF, you read the proposals given by the United Nations. So these kind of practices, which are age old practices, which had no justification at that point of time also, if they are prevailing in constitutional India, then it has to be stopped by the parliament. And I think it's a very welcome move by the honorable prime minister. And if it will be debated further in the parliament as well as before the law commission, a very good and healthy discussion will happen so far as this aspect is concerned.
Yes, Vishnuji, I completely agree with you as far as halala, FGM, and even arbitrary talaq. I would even say that, as far as that is concerned, that is really a domain of female rights or basic human rights, which needs to be addressed and done away with. And as far as one more thing I would like to ask you about is the Succession Act among Muslims. For example,
Yes.
in Hindus now we have, even in the Mitakshara, there earlier it used to be the men would go down the male ancestor three generations, and of course their wives could get a chair on partition, but the daughters could always get Stridhan, and they used to get their portion of the property as wives. But that again was amended, and women were also included as a co-partner.
Yes.
That is as far as co-partner property. And self-earned, we always gave it to women or boys or girls. We never discriminated. But whereas when we look at the Muslim Act, a
Yes.
girl
Yes.
a girl always gets half of what her brother gets. I mean, any
Yes.
position. So would that be addressed too, or would that be left out? How would it be taken care of?
I think that also will be addressed. And you have raised a very important issue, that under Section 6 of the Hindu Succession Act, the daughter was given an equal right by birth so far
Hmm.
as property of her father is concerned. And
Hmm.
that amendment was approved by the Honorable Supreme Court by judgment of Honorable Mr. Justice Arun Mishra, a very
Hmm.
well written judgment. So now that aspect which was there in our society, we have overcome that aspect also, and a daughter will be given a complete share so far as her brother is also concerned in a Hindu family by virtue of Section 6 of the Hindu Succession Act. But that aspect is missing so far as Muslim personal laws are concerned. And therefore I must tell you that under the Muslim personal law, a daughter gets 1/6 of the share, and after marriage she gets 1/8 of the share. So they have a particular logic that 1/6 is given because she will be given most of the portions of her property at the time of meher, at the time of marriage. Then she will also be entitled to certain portions of the property when she goes into the new household. So but I think that has to be seen, and the principle must be that they must be given equal property rights so far as Muslim daughters are concerned, Muslim sisters are concerned, right from birth. But I must also tell you that under Islamic law, as there the concept differs, we have a concept of succession or property rights by birth. Even the
Mm.
child in womb has a
Yes,
right over the property, but there the succession happens at the time of the death
there.
of the main member of the Muslim community, and there's no distinction between ancestral or self-acquired property.
Mm, mm, mm,
They can only do will so far as one third portion of their property is concerned. Then there's a doctrine of representation that if a man has two children and out of one children there are two more children, and if the main like if A has B and C as his
mm,
child and B dies, then B's children cannot take the benefit of succession, and it
mm,
will all the property will devolve to the second child, that is C. So there
mm,
are certain anomalies so far as Muslim laws are concerned. This which I've highlighted today on your show is called doctrine of representation. So these are the areas where which I think will be debated in the Uniform Civil Code. And if it is an issue of if it's an issue which does not fall within the concept of essential religious practice, then
mm.
Parliament and Law Commission will definitely deliberate and discuss upon those areas also.
Mm. Vishnuji, you just said that it would be discussed and then we can perhaps they would be taking it up. When that happens, wouldn't JFP property be affected? And one more thing I wanted to ask you, was it okay to give women right in co-pastory property of the Bindachara law, because these concerned big agricultural land and they were contiguous. There was a reason behind having it either going completely in the male line or the female line, because the people who lived there, because women otherwise got married and went out in patriarchal
Yes.
society, and in matrilineal society men married and came to the women's house. So it was all in one particular family, in one
Yes.
strand, either male or female. So introducing a woman there, did it? I think that I have got many complaints saying there's lots of friction and it led to a lot of partitions and even joint families breaking. And land is an economic, I would say, a base for the joint family to
See,
stick together.
See, the point is this, and you must analyze this aspect from this angle, that in today's era, and I'm talking about the practice which used to happen in the past, when a father used to marry her daughter, at the time of marriage, her share was given
Yes,
to the daughter.
yes.
That ultimately became as a kuriti, and we started calling it a dowry. And then
Mm-hmm.
ultimately the husband side used to take that property and used to think that they have a right over that property. So
Mm-hmm.
ultimately, when we have brought the Dowry Prohibition Act, there was no,
Mm.
we had stopped the gates for a
Oh.
daughter who is born in a particular family to get her share from her father. So
Mm-hmm.
therefore this section 6 was introduced in today's era, because I must tell you that whatever has been introduced in Hindu Succession Act, whatever has been introduced in Hindu Marriage Act, there
Mm.
was no discussion or deliberation so far as members of the Hindu community are concerned. One
Mm.
Mr. Jawaharlal Nehru one fine morning thought that Hindus must be codified. He had no guts to codify other members of the society. So he codified Hindu law, but
Mm.
without any discussion with the members of the society. So definitely there, and then there was a Dowry Prohibition Act which was brought. So my point is that when you are not giving the legitimate claim of a daughter
Mm.
who is
Mm.
born in a Hindu undivided family at the
Mm.
time of marriage. So
Mm.
therefore, Section 6 was implemented under the Hindu Succession Act so
Mm.
that she can be given her right by birth, and that right
Mm.
must be an equal right. This
Mm.
concept which I'm talking about is a concept under Islamic law, that a daughter will get one sixth of her share when she
Mm.
is born in a particular family, and at the time of marriage she will get one eighth of the share in the property where she is getting married to. But the
Mhm.
point is that whether we need uniformity so far as this aspect is concerned, we have to check that whether it falls within the essential religious practices or not. I do not have so far as much issue so far as this aspect is concerned,
Mhm.
because The issue is the main point is that a woman, whether she's a Hindu or she's a Muslim, she must get equal share
Yes.
in the property of her father or in the property of her husband.
Abs-
This must be the grand norm. This must be the grand norm. And therefore, with this principle, you can discuss and debate upon various personal laws.
Yes. I think Vishnuji, what about the aspects of, say, Jain system of Santara, where you had, would these practices also be affected?
See, Jain system of Santara was struck down by the Rajasthan High Court, and the
Mm-hmm.
matter is pending adjudication before the Supreme Court. But Jain system of Santara was practiced by Shwetambar Jains,
Hmm.
and the issue is that what it has been highlighted before a particular section of the society. It is not that simple. It's actually a way of adhyatmic kriya, where a
Hmm.
section of society who has attained that level of spiritual success, they peep into the other side and see that
Hmm.
whether what is the issue of birth and death, and
Hmm.
all the important gyanas, all the
Hmm.
important, when the chakras of your body are activated, then a
Hmm.
person performs santara. But it has been not understood by the honorable Rajasthan High Court, that by which medium these practices are practiced, who practices it, and what is the ultimate aim of this practice.
Hmm.
Therefore, santara, if it's an issue which will be discussed by the members of Jain community, there is no doubt about it. We will answer so far as Santara practices are concerned, and the legal position also I have highlighted before your show, that
Hmm.
Santara has been abolished, struck down as an unconstitutional practice by Rajasthan High Court. So I am asking a question, that if Santara can be struck down by the Rajasthan High Court, why not Iddat? Why not halala? Then why not female genital mutilation? Then why not adultery? Why not bigamy? Why not polygamy? Why not uniform age of marriage for child? So these are the issues which have to be addressed. The issue is this, that we all are ready to follow the law of the land. We believe that the constitution is the grand norm which is applicable to all the sections of the society, so it must be applied with iron hand to every member of the community, and there should be no exemption so far as their personal laws are concerned.
Absolutely, I agree with you completely on that, Vishnuji, that basic human rights should be implemented equally among all sections of the society, irrespective of their religion. So, I think it's a very wonderful session that you explained to us completely what areas
Thank you.
UCC would be looking at broadly. And Vishnuji, would you have liked the UCC coming up with a draft and then asking suggestions from the public at large and professionals like you?
Definitely, a draft will come forward. The suggestions of the Law Commission will not take a final shape. We all know that we are in a constitutional era where the Law Commission's duty is to frame a particular law. That law will be debated before the Parliament, before the Lok Sabha, then the Rajya Sabha. It will go before the Standing Committee of the Parliament, and it will first take a shape of a bill. So
Hmm.
there are a lot of stages so far as a particular law needs to be finalized and it takes the shape of an act. So
Mhm.
all those stages will be complied with, but I definitely believe that the suggestions of the Law Commission will be public before all the members of the society, and they then further have a time to give their suggestions or their corrections so far as the proposals of Law Commission are concerned.
Okay. Thank you so much, Vishnuji, for explaining the complete gamut of things that comes under UCC today. So we had with us Vishnu Shankar Jainji explaining what UCC consists of, or what exactly would come under UCC. So it actually would contain a complete uniform law as far as human rights values are concerned for women, and see to it that the human rights are maintained. Thank you for watching this broadcast.